Oh, okay. Geez, I lost my page. We're gonna read about federalism right now. Got a bookmark. Part 2 of constitutional law, subpart 4, relative spheres of federal and state powers. A, exclusive federal powers. 1, power of states expressly limited. Some powers are exclusively federal because the Constitution limits or prohibits the use of the power by states, for example, treaty power, coinage of money. And 2, inherent federal powers. Other powers are exclusively federal because the nature of the power itself is such that it can be exercised only by the federal government. For example, declaration of war, federal citizenship. Exclusive state powers. All powers not delegated to the federal government are reserved to the states. Note, however, that federal powers are given an expansive interpretation, and thus little state power is exclusive. That was part B of exclusive state power. So part C, concurrent federal and state power effect on supremacy clause. Because of the supremacy clause, the federal law may supersede or preempt local laws. Express preemption. A federal law may expressly provide that the states may not adopt laws concerning the subject matter of federal legislation. Express preemption clauses will be narrowly construed. Implied preemption. Conflict between state and federal law requirements. If a state law conflicts with federal law requirements, the state law will be held to be impliedly preempted. That's a nice way to say that. If a state law conflicts with the federal law requirements, the state law will be held to be impliedly preempted. State prevents achievement of federal objective. If a state or local law prevents achievement of a federal objective, it will also be held to be impliedly preempted if it prevents the achievement of federal objective. This is true even if the state was enacted for some valid purpose and not to frustrate the federal law. For example, the state law providing for suspension of driver's license of persons who fail to pay off an auto accident case judgment, regardless of the person's discharge in bankruptcy, is valid. Field preemption. A valid federal statute or regulation may impliedly occupy the entire field. Thus precluding any state or local regulation, even if the state or local regulation is non-conflicting. The courts will look at the regulatory scheme to deduce whether Congress intended to preempt the entire field. For example, if federal laws are comprehensive or an agency was created to oversee the area, preemption may be found. There's a presumption against preemption in all preemption cases, but especially in cases involving a field traditionally within the power of the states. For example, regulations involving health, safety, and welfare. Courts will start with the presumption that the historic state police powers are not to be superseded unless that was the clear and manifest purpose of Congress. Absence of federal and state powers. Some powers are denied to both Congress and the states. For example, the qualifications for serving in Congress are set by the Constitution and cannot be altered by Congress or the states. Interstate Compact Clause. The Interstate Compact Clause concerns agreements between states. If the agreement increases the state's power at the expense of federal power, congressional approval is required. That's an interstate compact clause concerning the agreements between states. And if the agreement increases the state's power at the expense of the federal power, the congressional approval is required. Now, inter-sovereign litigation is part 5. Suits by the United States against a state. The United States may sue a state without its consent. suits by a state against the United States, public policy forbids a state from suing the United States without its consent. Congress can pass legislation that permits the United States to be sued by a state in given situations. Federal officer as defendant. Limitation: a suit against a federal officer is deemed to be brought against the United States itself if the judgment sought would be satisfied out of the public treasury or would interfere with public administration and therefore is not permitted. So we're talking about the limitation on the federal officer as a defendant is that judgments can't be satisfied out of the public treasury. A specific relief against an officer as an individual will be granted if the officer acted ultra vires, which was beyond his authority. Suits by one state against another. One state may sue another state without the latter's consent. The Supreme Court has exclusive original jurisdiction. Subpart 6, intergovernmental tax and regulation immunities. A, federal taxation and regulation of state or local governments. 1. Tax or regulation applying to both state and private entities is valid. Congress may subject state and local government activities to regulation or taxation if the law or tax applies to both the public sector and the private sector, for example, minimum wage laws. 2, if a regulation applying tax or regulation applying only to the states. A federal tax or regulation that is not applicable to private businesses and that merely taxes or regulates a purely state or local governmental activity may be limited by the 10th Amendment. For example, requiring states to either regulate radioactive waste or take title to it is beyond Congress's power. That earlier note is kind of interesting. It's only congressional tax regulation is only valid if it applies to both the public and the private sector, such as minimum wage laws, which is interesting. So there's some exceptions to what I just read about the tax or regulation applying only to the states. 1, civil rights. Congress may restrict state activities that violate civil liberties. Exceptions. Number 2, spending power conditions. Congress may also regulate states through its spending power by imposing conditions on the grant of money to state or local governments, sometimes referred to as grants with strings attached. Such conditions will not violate the 10th Amendment merely because Congress lacked the power to directly regulate the activity that is the subject of the spending program if the conditions are clearly stated, relate to the purpose of the program, and are not unduly coercive. Weird requirements. Clearly stated, relate to the purpose of the program, not unduly coercive. Again, exercise of congressional spending power, conditions placed upon the state in exchange for the grants of money. So, as an exam tip, as a practical matter, the court almost never strikes down on 10th Amendment grounds a federal regulation or a tax that impacts state or local government entities. Thus, a choice on the MBE question that suggests that the 10th Amendment will invalidate a federal action is almost always wrong. And here's a little bit more about commandeering state officials. While not specifically resting on the 10th Amendment, the Supreme Court has held that Congress may not require state executive officials, for example, the police, to enforce federal laws because such requirement would upset the Constitution's dual sovereignty structure. For example, both the states and federal government are sovereigns. So Congress may not require them to enforce, like the police, to enforce federal laws. State taxation and regulation of federal government. A state may not directly tax federal instrumentalities without the consent of Congress. However, non-discriminatory indirect taxes are permissible if they do not unreasonably burden the federal government. For example, state income tax on federal employees. States may not regulate the federal government or its agents while performing their federal functions. So just reading that again, a state may not directly tax federal instrumentalities without congressional consent. We have drifted into the Privileges and Immunities Clause, which is Part 7, actually. And is this Roman numeral 7? Okay, so this isn't as long as I thought it would be. It involves Article 4, Privileges of State Citizenship. The Interstate Privileges and Immunities Clause prohibits discrimination by a state against non-residents. Note, corporations and aliens are not protected by this clause. In contrast, corporations and aliens are protected by equal protection and due process clauses of the 14th Amendment, as well as the Dormant Commerce Clause discussed infra. So 1, only fundamental rights are protected. 2, substantial justification exception. 3, note relationship to the Commerce Clause, and that will get us to the 14th Amendment. So just within Article 4, privileges and state citizenship prohibits a discrimination by a state against non-residents of the state when the discrimination concerns fundamental rights, i.e. rights relating to important commercial activities such as the pursuit of a livelihood or civil liberties. However, the clause applies only if the discrimination is intentionally protectionist in nature. I really like that definition. Substantial justification exception. The state law may be valid if the state has a substantial justification for the different treatment. In effect, the state must show that non-residents either cause or are part of the problem that the state is attempting to solve, and that there are no less restrictive means to solve the problem. Note relationship to Commerce Clause. Although the Article 4 Privileges and Immunities Clause and the Dormant Commerce Clause may apply different standards and produce different results, they tend to mutually reinforce each other. Consequently, they both have to be considered in analyzing bar exam questions. There's a little box here with an example. And rather than go through that, I'd rather just find my note card and read the note card analysis process. But in the meantime, I'm going to have it nearby. So, the statute in the facts is that $2,500 license fee is required from non-resident commercial fishermen, while residents pay $25. This is like 10 times the cost. So the statute giving resident creditors priority over non-resident creditors to assets of foreign corporations in receivership proceedings. So that's just another example of invalid discrimination. Statutes imposing a residency requirement for abortion, rule limiting bar admission to state residents, statute requiring private sector employers to give hiring preference to residents. And the discrimination upheld is when a statute requires non-residents to pay $225 license fee as opposed to $30 residence fee for recreational hunting. So that would be recreational rather than commercial fishery. So Part B under Privileges and Immunities is bringing us to the 14th Amendment privileges of national citizenship. States may not deny their citizens the privileges or immunities of national citizenship. For example, the right to petition Congress for redress of grievances, the right to vote for federal officers, and the right to interstate travel. Interstate travel, redress of grievances by petition to Congress, and voting for federal officers. And that brings us to part 3, which is state regulation or taxation of commerce. I don't really have the time to get into this right now.